Your blood is going to boil when you see the arguments that the government is using to strip people of their firearm rights. We're going to be getting to that last in this video because we have to work our way through it because, frankly, that's what the court does, so that's what you get to do as well. My name's Tom Grieve. I'm a former state prosecutor, criminal defense attorney. Today we are talking about a case that comes out of the Western District Court of Oklahoma, U.S.V. Harrison. We're dealing with 18 U.S.C. 922 sub G sub 3, where a judge has now struck down the cannabis ban for folks possessing firearms. Because, of course, as we know, 18 U.S.C. 922 sub G sub 3, or when you fill out your 4473 as purchasing a firearm, you have to answer the question as to whether or not you are a user of, among other things, controlled substances, but particularly, of course, they always ask about THC, marijuana, cannabis, all that kind of stuff, right? And you cannot be a user of cannabis or THC under existing law and be in possession of a firearm. If you do that, you're in violation of 18 U.S.C. 922 sub G sub 3, which, for those of you who are interested in rare trivia facts, accounts for only about 5% of federal prosecution cases under 18 U.S.C. 922. Most of those are actually going to be the felon in possession of a firearm. So only about 5% are dealing with the THC ban. In this video, we're going to be talking about some interesting legal topics that come up, including a ludicrous government argument for stripping someone of their rights. Again, we'll be coming up to that. Stay tuned. Here we're talking about whether or not, and the definitions for New York Rifle State Pistol Association v. Bruen. We're talking about the law-abiding citizen test. We're talking about who bears the burden of proof in Second Amendment cases that the laws are part of a historical tradition or not. In other words, the person who is contesting the law, so the normal civilian, do they have to prove that the government regulation falls outside historical tradition, or does the government bear the burden of proof? And likewise, we're dealing a lot with what the government argues is a tradition of keeping, their words not mine, presumptively risky. Imagine some air quotes there. Presumptively risky people like felons and mentally ill from possession. And should that extend to THC users because they are, their words not mine, unvirtuous? You can't make this stuff up, people. So when we're talking about the facts of this case, very briefly, this basically started the traffic stop. Mr. Harrison blew a red light, according to law enforcement. Officer makes contact at roadside, detects the smell of THC coming from the car. The driver, Mr. Harrison, acknowledges that he works at a medical dispensary where I believe he was on his way to for work at that point in time. Backup officer is summoned and arrives. They do a search on the car, and they find a loaded revolver on the driver's side floorboard, as well as some pills, as well as THC, cannabis, marijuana, whatever you want to call it. Gummies, vape, THC cigarettes, as well as stems. So he's now facing charges in two courts. In Oklahoma for the possession of the marijuana, paraphernalia, as well as failure to obey the traffic signal. As a note, he did not have the state-issued medical marijuana card. I'm not an expert in marijuana Oklahoma law. My working understanding, and I'm drawing on some inferences here, so let me know in the comment section how wrong I get this. But it seems like in order to be lawful in Oklahoma, I'm getting from the judges right up here that maybe you actually have to register with the state as a user, have doctor's permission, something like that. Let me know. Someone who knows, let me know in the comment section below. So he's facing criminal charges from the state on the one hand. Then, on the other hand, we get to federal court, where he was indicted by federal grand jury on August 17th, 2022, for possession of a firearm with knowledge that he was an unlawful user of marijuana. Again, contrary to 18 U.S.C. 922 sub G sub 3. I'm going to read that for you right here. It's also in the description box below if you prefer to be a visual, follow along sort of person. 922 sub G sub 3 reads, "It shall be unlawful for any person who is an unlawful user of or addicted to any controlled substance as defined by," and then there's a citation, "to ship or transport in interstate or foreign commerce or possess in or affecting commerce any firearm or ammunition or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce." A lot of technical words here. Basically what that means is virtually any piece of firearm or any ammunition, it is going to be illegal to possess if you are using some sort of controlled substance. Controlled substances here, if you click on those links, all that kind of stuff, you do your research. We're talking about Schedule 1 through 5, which for those of you playing at home are all the scheduled substances. So we're going all the way from meth all the way down to codeine-laced cough syrup. That's like a classic level 5, Schedule 5 controlled substance. So that's the low end. All Schedule 1s are basically presumed to be illegal under federal law for having no medical benefit. Don't shoot the messenger now. If you're curious and if you're like me and you're wondering, what's the definition of being addicted to, or what's the definition of being an addict? Well, I looked that up and I'm bringing it to you because you matter. So please take a moment to acknowledge that. It comes from federal law 21 U.S.C. 802, which very briefly says the term addict means any individual who habitually uses any narcotic drug so as to endanger the public morals, health, safety, or welfare, or who is so far addicted to the use of narcotic drugs as to have lost the power of self-control with reference to his addiction. Some powerful language there that I don't think I can recall shy of back when I was much younger and working on my theology degree, but there it is, now you have it. For those of you who may not have kept up on this, here's the current status of lawful medical THC, cannabis, all that kind of stuff. Medical cannabis, medical marijuana is lawful in 37 of the 50 states right now. Recreational cannabis is lawful in 21 states. Another 10 states have decriminalized the use of and possession of marijuana to varying degrees. So in some states, for instance, maybe it's lawful and it's only a ticket to be caught once. On your second or third or subsequent offense, maybe it turns into a crime. Here in Wisconsin, it's a crime on your first offense, and it turns into a felony on any second and subsequent offense, believe it or not, even if you're caught with shake or stems or something like that. So it's really easier for me just to name the 11 states where it's still a crime to possess on the first offense. We're talking Wisconsin, Idaho, Wyoming, Nebraska, Texas, Indiana, Kentucky, Tennessee, South Carolina, as well as Georgia. Important legal disclaimer here, I'm getting my information from the internet. I am not licensed to practice law in most of those states. So don't go out and buy marijuana and then say, hey, but this video online told me to do this. Be an adult, take some darn responsibility in your life, do your own research, okay? Now, of course, importantly, this remains illegal under federal law. Now we get to the court case. And before we do, please take a moment, if you've made it this far in this video, show some support, not only for us and our channel, but also for the Second Amendment. Click like in this video, click subscribe, let people know what we're doing out there, share the video around, we really appreciate it. The more subscribers we get means the more times I can basically take breaks in my day to bring you somewhat useful and maybe mildly entertaining takes as far as here's what the law is, here's what's coming out here. All right, so now we get to the court. I do want to preface the fact that this is coming from what's called a district court, federal district court. In other words, this is like a federal trial court. So the precedential value is limited to none, basically. But the judge wrote a very convincing and well-detailed 54-page opinion letter, which you can actually see in the description box below. Please feel free to check that out in there. But I do need to make it absolutely clear you cannot get arrested for being in a 922 sub G sub 3 individual, so firearm plus marijuana use, and say, oh, but this judge in the Western District Court of Oklahoma said it's okay. Just like you can't say, but this guy from the internet said it's okay. Neither of those are going to work here. No precedential value, but it may be of interesting persuasive value and hopefully a sign of things to come. What I really like about this opinion is the fact that the judge did a fantastic job of breaking down the arguments somewhat from Harrison, mainly from the government, and doing a fantastic analysis by applying the Bruen test, which we're going to get to in a moment. But let's kind of re-summarize what's going on here. So Harrison basically has a really simple argument. Harrison says, look, 922 sub G sub 3, which outlaws the possession of firearms by users or individuals who are addicted to marijuana, their words, not mine. There's no historical tradition for this, and that's the test we're working with in a post-Bruen world. The government says that Harrison is not a law-abiding citizen. Why is that important? Because under New York Rifle State Pistol Association v. Bruen, the Second Amendment only applies to law-abiding citizens, so the government says. So they're saying, look, he was in possession of marijuana, he's a user of marijuana, therefore he's not a law-abiding citizen, therefore he's not protected by the Second Amendment. By the way, that is not the blood-boiling argument, so stay tuned for that. Also, the government disputes as to who bears the burden of proof that the laws are part of a historical tradition or not. So the government is basically saying, look, we're not the ones that have to show that The law we're talking about here, 922 sub G sub 3, is part of the nation's historical tradition. Harrison has to show why it is not part of the historical tradition. In law, we call this burden shifting, and the sides may argue about who bears the burden of proof here. Okay, so Harrison is saying the government has it, the government's saying Harrison has it. Lastly, the government is arguing that there is, in fact, a tradition of keeping their words, not mine, presumptively risky people, such as felons and mentally ill from possession, and they should therefore extend to THC because it's unvirtuous. And again, please hang around because you're going to be maybe shocked, maybe not, but I think your blood's going to boil for most of you when you see what also the government argues particularly as part of that. So again, we've got the law here, and again, it's linked below. I'm not going to keep reading it, but I do want to give a brief, just 5-second take. I'm a lawyer, it's going to be longer than 5 seconds, but a very short take where 922 sub G sub 3 comes from. It comes from the Gun Control Act in 1968, and the statute initially prohibited any individual who was, quote, an unlawful user of or addicted to marijuana or any depressant or stimulant drug or narcotic drug, that's a paraphrase, from receiving a firearm. This was subsequently amended, I think in about 1986, to broadly prohibit the receipt or possession of a firearm by any person who is an unlawful user of or addicted to any controlled substance. And again, that's defined by Section 102 of the Controlled Substances Act, which you can find at 21 U.S.C. 802. Now, in its current modern form, found at 922 sub G sub 3, that's the charge Harrison's being charged with. That's what you see in your 40-40-73s. Basically, it strips a person of their fundamental right to possess a firearm the instant the person becomes an unlawful user of marijuana. And in the United States' view, of course, all users of marijuana are unlawful users regardless of the status of current state law because it remains illegal across all federal code. All right, so you've heard us talk about the historical test. For those of you who may not know, what the heck are we talking about here? What level of scrutiny, what is this test that a law that is seeking to regulate protected Second Amendment conduct, such as possessing a handgun, which is exactly what Harrison did here, what is this test that a law must get through to be held as being constitutional? Or if it fails to meet that burden, it gets struck down as being unconstitutional. Very briefly, from Bruen, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So that's right from the Bruen decision, cited here in this case, as well as in other cases dealing with the Second Amendment since the Bruen decision has come out. And prior to this, there was a lot of discussion, and we see it continuously come up, and I'm sure it will continue to come up, so I just want to throw this extra factoid in there for folks, that oftentimes one of the arguments when it comes to judges going along with what the legislature wants is presumably the legislature has a lot more information. They represent the will of the people. They're elected. Keep in mind, federal judges are not elected. But as a result, there is a wind out there that says that judges should exercise what's called judicial deference to legislative interest. And that's kind of part of those checks and balances and so forth. This judge in this particular case cited Bruen, which says that judicial deference to legislative interest balancing is understandable and elsewhere appropriate. It is not the deference that the Constitution demands, however, of course, when we're talking about Second Amendment protected language here. In other words, look, you can give judicial deference to speeding limit laws and all that kind of stuff because speeding limits are not constitutionally protected. Second Amendment, that is constitutionally protected. First Amendment, Fourth Amendment, all those sorts of things, right? So let's break down some of these arguments. And again, you're not going to believe what's coming here, all right? And I said, by the way, in a video probably a long time ago that some point we're going to reach this weird timeline where the government is arguing this, and we're here, okay? But we're coming up soon. All right, so let's break this down. So the government, of course, said that, look, basically, Harrison's breaking the law. Therefore, he's not part of the people who are protected under the Second Amendment. The government basically, or pardon, the judge throws this out as saying, look, the people are absolutely protected. You cannot create carve-outs for different individuals. So at the end of the day, look, no go. And obviously, unless you want to see a 3-hour video, I can't go into exquisite detail in every last little thing. If you want to see more details on any of these points, let me know in the comment field below. More interestingly, and I think of more interest to all of you down the lens, the government argues that, look, this is absolutely part of the historical tradition. And by the way, before we skip over it, yes, the government bears the burden of proof. I mean, if you heard me when I read through the Bruen decision saying, look, the government has to mandate this conduct, evidently the prosecutors in this case just failed to read that particular case, I suppose. I'm obviously being flippant. I hope they did, but I don't see how you could have a fair reading of what this U.S. Supreme Court said and somehow argue that you do not have the burden of proof. But just the same, here we are. So the government's now arguing, and they've pulled out 7 historical laws where they say there is history for stripping the Second Amendment from presumptively risky individuals. And I think broadly you can categorize these laws into 3 different categories. Laws that prohibit folks who are intoxicated from possessing firearms, laws that prohibit people who are convicted of a felony, and mentally ill. All right. So they pull out 3 laws, some of them going back to, I think, the 17th century, if memory serves. I think they dug up one from the colonies from 1655. Again, if you want the details of what all these laws are, let me know in the comment section below. Otherwise, I'm trying to keep this somewhat brief. Here's the problems for the government when it comes to looking at those 7 laws. I'm going to take them one at a time. The intoxicated laws only apply when the person is intoxicated. They do not apply for somebody who is a user of intoxicants. We're talking about alcohol here. And now because, you know what, they like to do some lawn bowling or whatever people did back in the 17th century for fun, and they like to have a beer, maybe some mead, wine, I don't know. Let me know in the comment section below if you know what people were doing back then for fun as well as their favorite drinks. But the point is just because they like to have a drink on Saturday or something like that, now they were a user of alcohol, doesn't mean that gun cannot possess firearms. None of the laws the government cited work that way, which is important because that's exactly the law that they're seeking to justify as being part of the historical tradition in 922 sub G sub 3. That's exactly how that works, okay? So the court points out this fact that, look, banning somebody from carrying when they are intoxicated is not the same thing, but it actually gets even better than that. So none of the laws appear to actually ban the possession itself. All right, so we're talking about carrying if it's on your person, you go conceal carry out, versus possession itself cannot have it in your household. Those are 2 different things. 922 sub G sub 3 bans the possession itself, but the 7 laws that the government cited, none of them seem to deal with possession in and of itself, but rather, for instance, one of them prohibits the discharge, but you're allowed to carry when you're intoxicated. So don't shoot your gun when you're drunk, but you're still allowed to carry. Another one deals with the sale of firearms to somebody who is actively drunk at the time. 3 others deal with prohibited carry, but again, not possession. So the judge does a fantastic job here of basically taking a scalpel to the government's arguments and saying, look, here's what the law is that you're trying to justify under the historical tradition analysis, and you guys can't point to anything that is analogous to that. All these are at best, somewhat distant cousins. Also, some of them, to my knowledge, actually, I think all of them only apply to public places. Again, we deal with that possession issue. So was this person's car a public place? Is someone's home a public place? Arguably no, and definitely no, yet 922 sub G sub 3 applies to it all. And the court actually has a really cool quote here, so I'm going to try to pull this up, where what the court says is, where the 7 laws the United States identifies took a scalpel to the right of armed self-defense, narrowly carving out exceptions, but leaving most of the right in place, 922 sub G sub 3 takes a sledgehammer to the right. That's a great quote, Judge. I really like that. Guys, please show your support for this judge. Click like on this video again. Some shameless shilling there, but hopefully we can show some support for this judge because they really did a fantastic job. All right, so now we get to felons. There is a difference between criminalizing felonious conduct, i.e., what this law is doing, 922 sub G sub 3, where somebody's not been convicted of a crime, they haven't gone through due process and so forth. We're simply saying, look, if you do this kind of conduct, now you can't get that. The judge draws a distinction between the fact that if we criminalize felonious conduct, then going through due process and ending a possible conviction, that is different than 922 sub G sub 3. We are stripping Second Amendment strictly based off of alleged conduct. And as a result, the prohibition against felons and the 922 sub G sub 3, these are very different because they are entirely different in application as well as in principle, where first you have to do something, go through due process, be convicted, now you become prohibited, as opposed to, oh, well, you use this or you are a user of this and you haven't been convicted of that or anything like that, but as a result, you now lose this core constitutional right. So the judge uses that to distinguish the two as being entirely separate, and therefore 922 sub G sub 3 falls outside tradition. Mentally ill, very quickly, and again, we're getting up to the blood boil one. It's coming. But the mentally ill one, the government basically cites all these laws that we'll see if they do turn out to be constitutional once courts start getting to them in a post-Bruen world. But notably, as the court pointed out here, the laws that the government cited deal with folks who are presumably violent or things like that. So in other words, we're talking about folks who, to use their language, not mine, they talked about dangerous lunatics. Okay, again, I realize that's not exactly politically correct, but hopefully you know that I'm quoting from the case here. All right, so the U.S. government in their arguments basically said, look, a lot of these laws deal with people who are dangerous and therefore they need to be disarmed. The judge, however, points out that there are likely about 400,000 Oklahomans who use marijuana under state law authorization. And lumping all of those folks into the category of being dangerous lunatics, the judge's description goes a bridge too far. Fantastic movie, by the way. Check it out. But it's a bridge too far. So basically says, nope, the mentally ill, you cannot lump this law in as part of the mentally ill for your anchoring in the historic tradition. Now we get to the obnoxious ones. So these are where, and I'm going to use a bit of a pun as you'll see, the government starts to throw out some Hail Mary passes of what can we do to basically make this stick. The government cites the laws that restricts slaves, freed slaves, Native Americans, Catholics, and loyalists, going all the way back to the 17th century from possessing firearms, basically arguing that, look, this is part of the nation's historical tradition. These laws, I guess, are worthy of citation. They're worthy of, in essence, pulling it out from the dead hand of history, pulling it out of history's trash bin. And you know what? These are salvageable. Raw for the glory days of when we used to prohibit freed slaves, Native Americans, and Catholics, and not to mention loyalists, from possessing firearms. Again, that would seem to be the logical conclusion of what the government is arguing. Importantly, the Second Amendment does recognize a pre-existing right with regard to this argument. In other words, the Second Amendment as well as the First Amendment are two great examples where the Constitution is recognizing a pre-existing right. It's not simply saying, look, we're going to carve out this right for people and maybe somewhere down the line it can be taken away. All the way going back to a case from 1871, the courts have said the First Amendment, the Second Amendment, these are recognizing pre-existing rights beyond basically place and time. And this is going to be very important because, as the Bruen case explained, when it comes to interpreting the Constitution, not all history is created equal. In other words, this is to say that, look, there's been some awful decisions that have been overturned. The Dred Scott decision is one such example as overturned, which did not recognize freed slaves as people. By the way, in part on the grounds that therefore freed slaves would have the Second Amendment. Gun control is racist. Look it up. If you want me to do a video on that, let me know in the comment section below. But as a result of this, the court says, look, we are not going to perpetuate this ugly tradition which has already been thrown into the dustbin of history. Leave it there. All right. So at the end of the day, Harrison prevails. 922 sub G sub 3 is struck down. It remains to be seen whether or not this will be appealed. I will keep you updated on this if you want me to know. But it's just shocking that the government thought that citing the laws disarming slaves, freed slaves, Native Americans, Catholics, that's good law. Let's run with that. Let's update this. This is what we need to have in the 21st century. That's pretty ugly. That's pretty dark. And unfortunately, a long time ago, I predicted that that's exactly what's going to happen. And we're here. That is what the anti-gunners are using. Guys, if you like this video, please show us again some support. Click subscribe. It helps us grow. Click like. Let me know in the comment section below, what do you like about this? What do you think is going to happen? Are they going to appeal it? What did you find most interesting about this video? What do you want to see follow-up videos on? I look forward to reading your comments, and we'll see you next time.